Now, flowing from that report, I sat down with senior legal practitioner Mr. Jiti Ogunye to look at some of the recommendations of the National Conference, especially on law and legal reforms. Delay in our justice administration is one thing that a lot of lawyers and litigants are worried about and often complain about. And it's against this background that I want us to look at the recommendations of the Committee on Law, Judiciary, Human Rights and Legal Reforms of the National Conference, headed by retired Justice Adeshola Oguntade. One major recommendation is the suggestion of a special court for anti-corruption cases. I know it's been a recurring issue, but the committee went further to say that such courts will be devoid of the niceties and technicalities of the conventional courts, such as preliminary objections, injunctions, and so on. It even made a recommendation that the court should be manned by retired judges, persons of proven integrity. So I want to get your thoughts about that. What do you think? Is it practicable or not?
No, I don't think so. I don't think that what is being recommended is either desirable or practicable. We can break it down. For example, when it's been suggested that retired judicial officers of proven integrity should man the court, why should that happen? If people retire at the age of 70, so why can't they go and retire? The illusion that those who are young cannot serve because they don't have integrity is just an illusion. So I am saying that for a starter, that shouldn't even be the way to go. If you have retired judges from the Court of Appeal to Supreme Court at the age of 70 and they are doing consulting job here and there now, they should just retire and be writing their memo. If they think that they still have something to contribute, they should go to the law school to teach or go to law faculties all over and contribute. No. They have retired. And so for me, you can't be suggesting that because you believe that that's the way to deal with anti-corruption cases. Secondly, I have always maintained that anti-corruption cases are not slow just because the judiciary wants it to be slow. In the chain, there are institutions that work to ensure that you have an efficient judicial system. And we're talking about the prosecution. We won't talk about the defense before we talk about the judiciary. If investigation was bad, the likelihood is that you are going to have dilatory prosecution because the prosecutor will then come and realize that the investigation was good, and then it will be looking for time and all that to perfect the imperfections in the investigation, which will never happen. And so the prosecution may not face up to the fact to then declare that the investigation was bad and therefore withdraw the case. The point is that it's not just the judex, the judge, that determines spacing in criminal justice dispensation. And so for me, if you are suggesting that you should create a special anti-corruption court because of speed, the question I pose is, why do you need to be that thematic? So are you going to create a special anti-kidnapping court, a special anti-robbery court, a special anti-rape court, and so on and so forth, a special anti-terrorism court? So why would you want to do that? It is unwieldy, it's not practicable. What needs to be done, and we've said this severally, is that you should reform the institutions. It is not by, look, before the EFCC and ICPC were established, there was the thinking that their mere establishment will help Nigeria, but what is our rating in the index right now? I hate to believe that these suggestions are not, in spite of the fact that they are being pushed by eminent personalities, are not well thought through. The call for the creation of anti-corruption court is not new. Farida Waziri trumpeted that before he left the FCC, as if that was the problem. And I've asked the question, The judges that we know, and I'm not going to mention names, that have cracked anti-corruption cases in record time, in spite of the fact that the lawyers that were lined up by the defense had the wherewithal as seasoned advocates to stall proceedings and all that, who have done this in record time. How did they do it? Why were those proceedings not dilatory? How did they do it? So it is not a question of creating a special court. Look, there are judges, as we speak, and they know, that are being asked questions because of the way they conduct their proceedings. It has nothing to do with what the system stipulates, but it has to do with the disposition of a judge as a human being, how a judge approaches his work. And so, for those judges who preside over cases, civil or whatever, they will not see it, or when they see it, they just give adjournments and all that, just fulfilling all righteousness and all that. We know those judges. So they are the system. So
should be the quality of the judges that emerge.
Exactly. If the quality of the judges is enhanced, the quality of adjudication in tandem will be enhanced. And I'm saying that it is not when you over-bureaucratize the judiciary that you achieve this result. You will be creating more problems by creating layers and layers and layers of courts, thinking that you are solving problems, but you are not solving this problem. That's my take.